To talk about this issue are two people who were involved in it at the time. Fred Wertheimer is now the president and founder of Democracy 21, but at the time of the case in 1975, he led a group called Common Cause, and that organization's Capitol Hill lobbying efforts to get passage of legislation that would limit contributions and would set spending caps for federal elections. He's also helped in the preparation of Common Cause's brief in the case. Across the table from him is John Bolton. He's currently a senior vice president of the American Enterprise Institute, and at the time of this case, in 1975, he worked extensively on the written briefs in support of overturning the law that placed contributions and spending caps on federal elections. Let me start with Mr. Wertheimer. What's your general statement on what this case is all about?
Well, this is the seminal case that addresses the issues of what can and cannot be done in the area of campaign finance laws. It came about as a result of the passage of legislation by Congress in response to the Watergate scandals that had occurred. And I was involved in the lobbying efforts. John Gardner headed Common Cause at that time. And a whole series of issues relating to the constitutionality of efforts to limit contributions and expenditures, to create a system of public financing of elections, to require disclosure of laws of campaign contributions, create an enforcement agency. At the heart of it, I think the court and everyone was struggling with two very basic values embedded in the Constitution and recognized ultimately in Buckley. One was the right of free expression, the First Amendment right to free speech, and a second value was the right of a political system, of a democracy, to protect its own integrity and protect it from being corrupted. And these two values, the protection against corruption, the protection of the integrity of the democratic process, and the rights of people to have free speech under the First Amendment, run throughout this case and throughout the history of campaign finance regulation.
John Bolton, your take on the importance of this case?
I think campaign financing is probably the single best issue that defines, for contemporary America, that defines where you stand in the debate between the liberty of the individual on the one hand and the power and authority of the government on the other. I think the values that were at stake here clearly were constitutionally significant, and they largely described whether people believed in a free and essentially unregulated political system on the one hand versus those who would take the model of the economic regulatory state and apply it to politics on the other.
Who did you work for at the time, and what was your position in the case?
Well, I was a very new attorney at the law firm of Covington and Burling here in town, and I had previously been a research assistant to Ralph Winter, professor at Yale Law School, my alma mater. Ralph had been one of the leading theorists in opposition to the post-Watergate so-called reform statutes, and he had been in touch with Senator Buckley, who was an opponent of those statutes. And when I went to Covington and Burling, I looked for a partner in that firm who'd be willing to take this potential case on pro bono, that is to say, we did this for no fee. I found Bryce Claggett, who was a partner at the firm at the time. He and Ralph and I, an attorney for the American Civil Liberties Union, Joel Gore, were the four principal attorneys for the plaintiffs.
And John, Fred Wertheimer, your position, your precise job in this case?
Well, my job was not being one of the principal attorneys for the folks on the other side who were defending the statute. As I said, the statute came about as a result of enormous abuses in the role of money in politics, abuses that resulted in the buying of access and influence over government decisions, abuses that resulted in the sale of ambassadorships, abuses that led to dozens of corporate executives being criminally convicted for breaking the law. And this was an effort to try to create a new system in which the integrity of the political process could be protected, and from our perspective, also that challengers could have a better chance to run for office against incumbents. And the heart of that for us was public financing of elections.
In terms of the case, then you, Fred Wertheimer, were on the Valeo side?
Yes.
And John Bolton, you were on the Buckley side?
That's correct.
The Buckley being Senator?
Jim Buckley of New York.
And what was his specific complaint that led to the lawsuit?
Well, Jim Buckley had been elected senator from New York as a conservative. He had run neither on the Republican nor the Democratic Party tickets. And he, along with former Senator Eugene McCarthy, who was running as an independent candidate for president, believed that the contribution and expenditure limits would limit the speech of dissident minority points of view. And they feared that the result of that would be a perpetuation of incumbents in office. One of the nicknames for this statute was the Incumbents Protection Act of 1974. They also opposed the public financing provisions as being a backdoor way of gaining governmental control over the political process, and they opposed the enforcement mechanism, the Federal Election Commission, as being unconstitutional in violation of the separation of powers. So they opposed virtually everything in the statute.
Fred Wertheimer, who is Valeo and why is he the defendant?
Well, Frank Valeo was the Secretary of the Senate. You might want to answer why he was the defendant, but at the time prior to the taking effect of the Federal Election Campaign Act of 1974, campaign finance disclosure reports were filed with the Secretary of the Senate and with the Clerk of the House. And even as the Campaign Finance Act of 1974 was passed, the Secretary of the Senate and the Clerk of the House still require that the reports come to them first before they went to the Federal Elections Commission. But again, I don't know the precise reason why Mr. Valeo found this place in history.
Is there a more precise explanation?
We filed this case on January the 2nd, 1975, which was the first business day after the effective date of the statute. At that point, the Federal Election Commission, the 6 appointed members, had not yet been appointed. But as Fred said, Valeo and the Clerk of the House were ex officio non-voting members of the Commission. We named Valeo as the lead defendant because we wanted the Commission in the case right from the beginning.
So if you'd waited longer and there had been an FEC, then it would have been Buckley versus somebody else.
Possibly, that's right. We had no intention of waiting. It was too important to move quickly.
Well, tonight we're going to spend a lot of time listening to the actual words of the lawyers in front of the then 8 members of the Supreme Court, and we'll get into why there were only 8 a little bit later. And these oral arguments on audio tape haven't been widely available, so we're pleased to have them tonight. The first one is very brief, and you've already mentioned John Bolton, attorney Ralph Winter, who's going to talk for a couple minutes here, where he, just to give you a flavor of what's going to happen the rest of the evening, he spends a few minutes of precious oral argument time laying out who's going to say what when. And can you comment on what we're going to hear?
Could I just say one thing on that? Normally, arguments before the Supreme Court in contemporary times only last 1 hour, and typically there's one attorney on one side and one attorney on the other, each arguing for half an hour. We knew this case was significant, and the fact that the Supreme Court allocated what ultimately became 4.5 hours was a very unique situation. So one of the things Ralph was doing was just laying out for the court what was to follow, because it was such an unusual situation.
Well, here it is then. It's only a couple of minutes. It's Ralph Winter telling the Supreme Court how the various parties are going to lay out the time between themselves for the next 4.5 hours.
We'll hear arguments today in Buckley against Valeo and others. Counsel, you may proceed whenever you're ready.
Mr. Chief Justice, and may it please the Court. This case was brought on January 2nd of this year, the first business day after the effective date of the Federal Election Campaign Act amendments of 1974, which I will refer to as the FECA. It sought a declaratory judgment of unconstitutionality and a permanent injunction against the enforcement of major provisions of that law. The 1971 Federal Election Campaign Act and Subtitle H of the Internal Revenue Code, as amended by the FECA amendments. Pursuant to the expedited review provisions, the case was certified to the Court of Appeals for the District of Columbia Circuit. after a remand to the district court for fact-finding, a framing of the constitutional issues, and a recertification to the Court of Appeals, the Court of Appeals and a 3-judge district court, considering only Subtitle H, rendered their opinions on August 15. The majority below upheld the constitutionality of every major provision of the law but one. That provision was not appealed and is not an issue here. The allocation of argument for both sides will be as follows. I will discuss the statutory limits on campaign expenditures by political parties, committees, and candidates, limits on contributions to political candidates, and limits on independent expenditures. My colleague, Mr. Gora, will discuss the challenge to the Act's disclosure provisions, and this afternoon, Mr. Claggett will argue the unconstitutionality of federal subsidies to political candidates and parties and of the Federal Election Commission. For the appellees, Mr. Friedman will discuss general principles and the disclosure provisions. Mr. Cox will discuss the limits on expenditures and contributions. In the afternoon, Mr. Cutler will discuss Subtitle H, and Mr. Spritzer, the constitutionality of the Federal Election Commission.
Now, it was the Supreme Court over 20 years ago, and we're going to be taking your calls and faxes and so forth in about 15 minutes or so. We want to hear more from our guests, Fred Wertheimer and John Bolton. Whose voice was the first voice we heard in that clip, Fred Wertheimer?
Chief Justice Berger.
You were there that morning?
I was there that morning. I had the work I had done in this case really had flowed from what I had been doing for the last couple of years, which was engaged in lobbying efforts on behalf of the legislation. So my work had focused on somewhat on the legislative history and also on the preparation of the factual record for this case. But when I walked into the court that morning, and I had not been in the court, I'd been there once before, and sat down, just from my perspective as citizen, I was stunned by the nature of how absolute the power was, because I had been involved in the political process, in the lobbying, the legislative process, and then I walked in there and sat down, and all of a sudden, from nowhere, these justices appeared, and then I realized, you know, nothing else now mattered. They were going to decide, and what they decided was the end. It was absolute, subject, of course, to whether you could change them years later. But the awesome power of the Supreme Court became very clear to me in a way that I had never quite understood in law school.
John Bolton, your impressions?
Well, I was sitting next to Ralph Winter at council table, and we had spent weeks in preparation for this moment. Indeed, we had spent virtually the entire year in preparation for the moment. And as Ralph Winter described, he was about to argue one of the most important issues, the contribution and expenditure limits, against Archie Cox, who, of course, at that time was famed as the Watergate special prosecutor. I wanted to be sure Ralph was up for this argument. Ralph and I were both graduates of Yale College and Yale Law School. Ralph was a professor at Yale. Archie Cox had been to Harvard. He was a famous Harvard professor. Right before Ralph got up to give those opening remarks, I passed him a note that said, "Go Yale, beat Harvard."
Fred Wertheimer, who is arguing the case on the other side?
Well, Archibald Cox was arguing it, argued the contribution and spending limit provisions. Lloyd Cutler represented one of the intervening defendants and argued in favor of the constitutionality of public financing. The Solicitor General's office argued a general overview and the disclosure provisions. And then I believe Ralph Spritzer argued for the Federal Election Commission, who themselves were represented at the oral argument in defense of their own position, since the constitutionality of the way they had been created was being challenged in this case.
So, John Bolton, over 4 hours, most cases, as you noted, get only an hour. What was so momentous that this case would generate 4 times the amount of time that the court would otherwise dedicate to a case?
every one of the issues that we had brought in the original complaint challenging the constitutionality of this vast array of statutory provisions involved very important constitutional questions, First Amendment questions, separation of powers questions, a whole range of things, many of which were essentially questions of first impression for the court. They had never really been confronted with a statutory mechanism like this. And I would say I had something of the same impression of Fred's, that there was so much to be decided that in fact we worried that perhaps, that was the one moment we worried perhaps we had challenged too much. There was just so much to explain, and 4.5 hours is a long time, but it didn't seem very long to us.
One of the unusual natures of this case was basically every major concept in this statute was being challenged on a constitutional basis. Now, you usually don't see that when you wind up in court.
We're going to get into the heart of the argument. This one coming up is on campaign expenditures. We're going to hear Ralph Winter and Archibald Cox, both of them, but quickly, give me a sentence or two on the campaign expenditures portion of the statute and what was being challenged.
The Congress had rejected public financing for its own elections, but created a system of mandatory spending limits for congressional races. They had also enacted limits on the amount of personal wealth a candidate could expend on their own behalf. There was a $1,000 limit on what an individual or group could spend independently. And then there was another spending limit as part of the public financing system for presidential elections.
All right, for the next 12 minutes, this portion of the oral argument in front of the Supreme Court in Buckley versus Valeo, I want to warn you that the justices, when they come in with their questions, aren't quite as well mic'd as we would prefer. So listen closely. You can hear the attorneys very, very clearly, and then we'll come back and take your phone calls in about 12 minutes.
I want to confront directly and in detail the contention that the FECA is not facially discriminatory, for there are several clear cases of facial unconstitutionality. Section 608 limits contributions to and expenditures by candidates as defined in Section 591, essentially as anything of value given or employed to influence a federal election. Title 39 U.S.C. Section 3210, which is on page 81 of our Volume 3 of the appendix. That section in subsections E and F explicitly makes explicit exceptions to the definitions of contributions and expenditures. What the exceptions are funds used in preparing material to be sent out under the frank, as well as the postal value of sending it out. Section 3210A3 defines the kinds of materials that may be sent out under the frank. That describes a variety of relevant materials which clearly influence elections, but most particularly it includes, and I quote, discussions of proposed or pending legislation or governmental actions and the positions of the members of Congress on and arguments for or against such matters. The only limitation is that that frank cannot be used within 28 days of an election. Now, since the presentation of arguments for and against actions by Congress obviously influence elections, the effect is that Section 608 limits all contributions to or expenditures by challengers for purposes of mailings which debate governmental issues, while leaving totally unregulated and unlimited private contributions to incumbents to prepare material, which is then sent out in unlimited amounts at government expense. No party to this litigation, so far as I know, disagrees with this interpretation of the statute. Indeed, even in the proposed regulations of the Federal Election Commission relating to office accounts, the Commission was at pains not to treat funds supporting the activities described in Section 3210 as either contributions or expenditures. The issue we raise is not whether congressmen should be able to communicate with their constituents. The issue is whether Congress, under the First Amendment, may by law limit the ability of challengers to communicate with the very same constituents without similarly limiting itself. Of course, public officials need to communicate with voters, but so do challengers. And if private contributions to challengers for use in mailings are to be limited, since they may corrupt or give the wealthy an unequal voice, then contributions to incumbents for the same purpose should also be limited. The situation this statute establishes permits an incumbent congressman, say in a plausible hypothetical, to accept $40,000 from a source, any source, which can then be used to prepare, and it doesn't have to be disclosed, which can then be used to prepare materials. You can give them, you can hire an advertising firm to prepare materials which can then be sent out under the frank. So that an incumbent congressman might accept, give an advertising agency, say, $35,000 to prepare materials, send out 150,000 copies of something which I suppose is worth maybe roughly $15,000, none of which counts either as a contribution or an expenditure. If the challenger were to do exactly the same thing with matters debating the pros and cons of governmental action, it would all be subject to the limits. And indeed, in the hypothetical I've given, a challenger in the House would have used up well over half the expenditure limit, and that's before he has hired his lawyer and his accountant to help him comply with this statute.
Are you directing yourself to a Fifth Amendment attack or a First Amendment attack, or both?
I think it's both, Justice Stewart. It seems to me that it's a Fifth Amendment attack in that it's an invidious discrimination, but it's also a First Amendment attack in that it clearly regulates content. It permits more speech, greater speech by incumbents than by challengers. I think it is almost exactly the case that the court decided in Police Department against Mosley involving a statute that prohibited all picketing, but picketing by a labor organization. So I think that the attack goes on both grounds. Now, if that's not facial discrimination, then these words have lost their meaning. It's not a minor exception.
The First Amendment doesn't have much to do with discrimination as such, does it?
Well, I
the Fifth Amendment does, of course.
Yes, it does. I find it difficult, Justice Stewart, though, to see why a statute which prohibits the speech of some but not others in a discriminatory fashion does not violate the First Amendment.
Well, so far as it's directed to content, it certainly does.
Well, that is content in a very real, very, very real sense. And not only that, the First Amendment at the core is the protection of those outside the government. This smacks very much of the repression of political opponents in that people outside the government are not allowed to speak as much as people in. And I think that's, if the court finds the statute does that, it's a clear violation of the First Amendment.
Mr. Cox, as I understood you, you expressed the view that a challenger is not disadvantaged by this act. May I put this hypothetical to you? Suppose the challenger is in a district from which the member of Congress, has served, say, for 10 or 15 years, and therefore is very well known. Assume further that the entire media in that district supports the incumbent. Would you think he'd have much of a chance? I realize it would depend on the facts and circumstances, but isn't he disadvantaged?
I was speaking, Justice Powell, in terms of the general impact. I will agree that you can think of cases where the only way in which a man could win was by having to spend enormous sums of money himself because everything else was stacked against him. And I was thinking of the generality. I got into it by attempting to grant to the Chief Justice, in answer to the Chief Justice's question, that if the overall limit on spending were very, very low, then the man who has recognition to begin with, of course, would have an advantage. The point I was seeking to make was that the ceilings here are not that low. And I think that again is shown by experience. And of course, the burden of showing isn't on those defending the statute, it's on those attacking it. But if you look at the ceilings on the basis of the 1974 election, it seems that they give ample chance to challengers to gain recognition. And second, that taking the act as a whole, they hurt incumbents who probably have the greater money-raising capacity more than challengers. Let me give just a few figures. I pointed out a moment before that only 3% of all the candidates in House races, it's a little less than 3%, exceeded the ceilings in 1972, 1974, even after 72 was adjusted for inflation. Of the 40 successful challengers in 1974, only one exceeded the ceiling. Of the 28 challenger winners in close races, that is where the winner got less than 55% of the vote, the average spent was only $95,000 out of an overall ceiling of $168,000 for the combined primary and general election. Of the candidates in close races in both primary and general election in 74, only 4 of 59 exceeded the combined ceiling. So there really is very little ground for arguing that these ceilings, which really check the skyrocketing increase rather than cut anything very much back, particularly in the congressional races, don't allow adequate opportunity to become known. And I can find no basis for arguing that on the whole, they discriminate against challengers. I think if they do anything, they hurt incumbents more than challengers.
Does the legislative history show that the kind of analysis you've just given us?
Did Congress what?
Did Congress make the kind of analysis in fixing these limits that you've just been suggesting?
I am not able to say that it did. I think one must assume that many members of the staff and others did study these things, and I am informed.
I just wondered whether the legislative history revealed that kind of analysis.
Perhaps I have a moment after lunch in which I can answer your question, Justice Brennan.
But at least Congress decided what the limits were going to be.
Oh, yes, after considerable discussion.
Apparently thought that this would be enough money for anybody to...
And these were men who had run in many, many races, sometimes most recently as winners, but I have no doubt many of them sometimes as losers.
The deference that you might give to a congressional judgment to how much money might be appropriate may not be the same when we're talking about how much incumbents thought challengers might need.
Well, I find it hard to believe that all 435 favor incumbents entirely. I recognize the point. I recognize, too, that this is a First Amendment case and that the judgment perhaps requires somewhat closer scrutiny, but I wouldn't think that the court should simply act as a legislative body. Excuse me.
Your answer apparently is what you've already given, that based on history, incumbents won't do any better under this than challengers.
That is correct. And indeed, I think if the history shows much either way, it shows that the incumbents are hurt more because they nearly always spend more, both when they're successful and unsuccessful. And this we draw from the figures on the close races.
I take it your answer gives some weight to the fact that incumbents have a lot of built-in assets that challengers do not have, namely large office staffs and branch offices out in districts and that sort of thing.
I recognize that...
Plus newsworthiness to what they do that challengers don't always have.
There's no question but that incumbents have advantages. Sometimes they're disadvantages, but they're likely, through name recognition, to be advantages. My proposition is that this statute does not make challengers any worse off in that respect than they were before.
22 years ago, that was one piece of the oral argument on the campaign expenditures portion of the discussion, and I want to ask John Bolton, how do you think Archibald Cox did in making his point in that segment?
Well, this being the Christmas season, I want to say everything in the Christmas spirit, and in that spirit, I think Ralph Winter made mincemeat of Archie Cox on that argument. I haven't heard that tape, I haven't heard those voices in 22 years, but it brings back memories now of Archie Cox saying that, that incumbents were hurt more by expenditure limits than challengers. There are 535 people on the Hill, all of whom I'm sure disagreed with that statement. The point that Ralph Winter was making is that is that incumbents start off with enormous advantages, and limiting challengers and incumbents to the same expenditure levels, one analogy we used is like starting a basketball game with one team 20 points ahead and giving both sides 15 shots at the basket. I mean, that's the discrimination argument. That's not the other First Amendment argument we made, which is that any expenditure limit, whether it was discriminatory or not, was violative of the First Amendment.
We're going to open the phones so you can participate, so you can use the phone numbers that appear on the bottom of your screen. If you're in the Eastern or Central time zones, you can dial 202-624-1111. If you're calling from the Mountain or Pacific time zones, it's 202-624-1115. And if you want to give us a fax, it's 202-393-3346. And if you want to reach us via email, the address is programs@cspan.org, C-SPAN with a hyphen. We'll repeat those numbers a little bit later on. Fred Wertheimer.
Well, first of all, the court didn't decide the spending limit question on that discussion about incumbents versus challengers. It decided on the argument that, that this was restricting both the quantity and diversity of speech spending limits were. And whereas contribution limits, they found, had a compelling state interest in protecting the government against, and the political system and the people against corruption of elected officials in government, and therefore upheld the constitutionality. Here they found it was restricting direct speech and therefore held it unconstitutional, with one very interesting caveat. In a footnote, the court basically said that you could voluntarily agree to spending limits if you received public funds in return. So they upheld spending limits in the public financing system. I must say, I have to point out here that as a result of that, we only had spending limits in presidential elections. John has now twice talked about the incumbent protection nature of spending limits. But in the only real application we have had of this at the federal level, challengers beat incumbents in 2 of the first 3 presidential elections and in 3 of the 5 presidential elections that involved incumbents and challengers, not an Incumbent Protection Act by any means.
Let's go to the phones. Our first call as we look back at Buckley versus Valeo, Clearwater, Florida. Go ahead, please.
Yes, good evening.
Good evening.
This is a great service to have the actual arguments from the Supreme Court communicated to everybody across the country, and I'd like to put a pitch in for having the Supreme Court televised. But I wanted to also note that I think it's an appropriate time for these 2 gentlemen to be discussing this case when we've had the circumstances of congressional hearings, identifying that we have a president who's diverting huge resources of time and interest in accumulating money for his own reelection and his party's reelection. We've got on the record the fact that...
Tell you what, caller, what we're trying to do is focus on the issues back then and how they're influencing the debate today without getting into, frankly, an awful lot of facts and different people's different views of those facts. So why don't you, in that spirit, pose your question to our guests?
Yeah, doesn't Mr. Bolton have a blind spot without prohibitions on amount of money that candidates and public officials, more importantly, can try to accumulate for themselves and for their own reelections, without some sort of regulation that you have a laissez-faire relationship between money and our government? And then that is the issue that Buckley versus Valeo was addressing, and I think appropriately so.
Thank you, sir.
Well, the argument about contributions that we were making was that limits on contributions we felt were restrictions on speech, just as the expenditure limits were. And as Chief Justice Berger pointed out in his separate opinion in the case, contributions and expenditures are really 2 sides of the same First Amendment coin. The argument about undue influence caused by contributions we felt could be handled by adequate disclosure. If people feel that their candidates are being bought by special interests, let them express their displeasure at the polling booth. The problem with the limits and the restrictions is that it invariably has a distorting effect on the political process. And I would argue one of the problems we're experiencing today that you complained about earlier is the artificiality of these limits. I think if you remove the limits entirely, had sufficient disclosure to allow the public to make an informed choice, they could say whether they're bothered by this or not.
The court disagreed with this position. Chief Justice Berger's position was a distinct minority here, and by 6-2 vote, I believe, the court upheld the constitutionality of contribution limits, said that there was justification and need for them, rejected the idea that disclosure in and of itself was sufficient protection, and in effect accepted the Congress's determination that contribution limits were necessary not just to protect against corruption, but against the appearance of corruption, and said the appearance of corruption itself is sufficient justification. And more than 25 years later, or almost 25 years later, those contribution limits are still on the books, and Congress certainly has not repealed them.
Our next call is Spartanburg, South Carolina. Before we go to that, though, the last caller's comment about the audio tapes brings to mind a little-known fact that these audio tapes have been in the archives since 1955. So if you want any oral argument that far back, it can be had from the National Archives, and you can reach the National Archives at 8601 Adelphi Road, College Park, Maryland, 20740. And we've even got a phone number there for you, 301-713-6800. That's where we go to get them. They're available to any American. Next call, Spartanburg. Go ahead, please.
Yes, sir. Good evening, gentlemen. Yes, I would like to say that I think the contributions the limits should just be taken off. I mean, if you really want to empower a voter, you give them the right to contribute politically. And in some cases, people are so busy that political activity is a contribution. And the 1,000 limit, that's 25 years old. It's outdated. And if you just look at my state, my senator, the retired Senator Heflin and Ted Kennedy, there's 100 years of service right there.
Okay, sir, thank you. John Bolton, did anybody make the argument, or did you make the argument, just eliminate everything?
We said the contribution limits were unconstitutional, and I think that that it is a basic concept about free speech, that if people want to contribute to somebody whose views are shared by them, whose interests are advanced by them, we thought that was legitimate political activity and should have been protected by the First Amendment.
Carlsbad, California. Go ahead, please.
Yes.
You're on the air.
I have always felt that success in life and gaining financial freedom for yourself is a pretty good indicator of how you may serve in public life. And I have no problems with unlimited amounts of your own money being spent. Or also, I feel that if you have the ability to attract money from other people who agree with your point of view, that's an asset. Why should we punish people for that? I strongly oppose, however, public financing. I think that is completely beyond the bounds of how our system should work.
All right, ma'am. Thank you. Fred Wertheimer.
Well, I think history, and not just the history of this country, but the history of civilization tells us that one of the great dangers for any democracy is the corruption of that democracy. And history also tells us that one of the central ways in which a democracy, a civilization, has become corrupted is when those who are supposed to represent all of the people, in effect, become obligated, indebted, financially dependent, or in effect sell the government to a relatively few people for large sums of money. We've had bribery laws in this country for a long, long time, and no one has particularly challenged those. When a campaign contribution takes on the nature of a legalized bribe because it has the capacity to obtain government decisions at the expense of the rest of us, that's very dangerous, and that, in effect, is what the Supreme Court upheld in Buckley.
To both of you who are listening to these tapes, the justices are interrupting the arguments, but have things changed in the last 22 years, John Bolton?
You mean in terms of
that regard?
About the justices interrupting?
Yes.
No, I think if anything, most Supreme Court watchers would say that the questions come more frequently now, at least from at least some of the justices.
You agree, Fred Wertheimer?
I'm not as experienced in this, but that's my impression. In fact, sometimes the arguers today have a tough time getting their arguments in because the justices are arguing with each other through the people presenting the cases.
In that last clip, there was frequent reference to the frank. What is that?
Ralph Winter, in particular, was referring to the congressional franking privilege, which is a statutory creation of Congress that allows them to send mail at no postage cost to their constituents. It was one of the examples we used for the enormous advantages of incumbency that may be perfectly legitimate for the members of Congress to communicate with their constituents, but it leaves them far better positioned politically, much greater name recognition and so on, and it was one of the reasons we argued challengers should be left without expenditure limits in order to make their case to the voters.
Coming up next, C-SPAN's Lou Ketchum interviews the lead plaintiff in this case, former Senator from New York, James Buckley. He's now a judge on the U.S. Court of Appeals for the District of Columbia, about what his position was then and what he thinks of the case and why he brought it. That's going to be about 12.5 minutes. When we come back, we'll continue to take some of your calls. You can reach us from the East and the East Coast and the Central Time Zone at 202-624-1111. From the Mountain and Pacific Time Zones, 202-624-1115. And you can use our fax as well, 202-393-3346. We'll be back after hearing from the lead plaintiff, Senator James Buckley.
Judge James Buckley, in discussions of campaign finance reform, the Supreme Court case of Buckley versus Valeo is cited, and you're the Buckley in that case.
Yes.
How did your name come to be on that case?
Well, I was in the Senate at the time that this legislation was being debated, and I had come to the Senate in a rather strange way. I was the first candidate of a third party to enter the Senate in over 40 years, and I challenged an incumbent. So I understood the difficulties in two dimensions of challenging an incumbent. Number one, there are extraordinary advantages of being in office. Number two, it is extraordinarily difficult for somebody other than a Republican or a Democrat to get the kind of hearing in the political marketplace to get you admission. Another fact is that on entering the Senate, I was sworn to uphold the Constitution of the United States, which in my judgment means that each member of Congress has got to ask the question, is this constitutional? And I thought the restrictions, especially restrictions on political speech, which is in the heart of this legislation, was clearly contrary to the core value that was being protected by the First Amendment, namely the freedom of political speech. Number two, the restrictions that were being placed on what an individual can contribute, what candidates could spend in a campaign, would have the effect of making it, of loading the dice even more in favor of incumbents. It would make it terribly hard for reform groups, for unknowns and so on, to achieve that basic credibility that would give you a fair chance.
What was the political atmosphere of those times?
This was in the wake of Watergate. Maybe Watergate was still going on. This was, I think this legislation was being debated in the early spring of '74. Well, there had been some real scandals in terms of money raising, particular individuals and so on, who became appointed ambassadors and things of that sort. Not that that practice has disappeared by any means. And also, there was an organization called Common Cause that decided that money was evil, and that the fact that campaigns had to be financed, and that the money came from contributions from In my case, over 40,000 individuals contributed, raised all kinds of suspicions, and therefore this justified throttling political speech. And I think that people sort of got caught up in that swing. But the amusing thing about this is that the people who were supposed to be the reformers were members of Congress. And very shortly after people started examining the specifics of this legislation, it came to be called the Incumbent Protection Act of 1974, and it has in fact acted to protect the privileged positions of incumbents.
We'll touch on that in a minute. Who was Valeo?
Valeo was the Secretary of the Senate.
And was your name the sole name, or were there others?
No, there were a number of plaintiffs. I happened to be the lead plaintiff because I was there right where the action was being done, and I guess I sniffed out the problems a little earlier than others. But I was joined by a strange coalition, and I think one that is very informative as to the nature of the issues that are involved in this case. The number 2 man was Eugene McCarthy. And if you may recall, Eugene McCarthy was a senator who in 1968, he was very much passionately anti-Vietnam involvement, and that led him to challenge Lyndon Johnson for the Democratic nomination in 1968, and he did so well in New Hampshire that Johnson decided to give up seeking election. Also was the very left-of-center New York Civil Liberties Union and the equally right-of-center American Conservative Union. There was a Libertarian Party and a gentleman, a philanthropist of great wealth, Stuart Mott, who his vocation was finding liberal causes to whom to give financing. Now, what this group of plaintiffs had in common was a concern that independent voices, that new voices, would be frozen out of the political process.
When you hear the debate today, I want you to compare what you hear being debated today about campaign finance reform with the debate then. What do you hear today that's similar to them, but also what's different?
Well, first of all, there's been a little experience first of all, what happened in between was the Supreme Court. The Supreme Court decided in Buckley versus Valeo that some provisions were clearly unconstitutional, and in other instances it said that the restrictions on speech were justified because of the appearances of corruption. And this had the bizarre effect of making it possible for very wealthy people to walk into the political limelight, finance their own with no limitations on what they could spend on themselves, because obviously they couldn't corrupt themselves, while at the same token making it impossible for private citizens to speak up in the political marketplace in support of somebody else whom they believed very strongly in. You have the bizarre effect that the owners of the New York Times are able to use their huge power to advocate and spread the message of a candidate of their choice, whereas nobody, no individual, can buy even a quarter of a page, can afford to buy even a quarter of a page in the New York Times to say, sorry, we object. So a lot of the debate you hear today focuses on the fact that a Ross Perot or Stephen Forbes can go in there and somebody else can't. Now, the obvious answer is let Stephen Forbes, who has an enormous draw, collect 50,000 from this. Well, put it this way, not Stephen Forbes. Let you, if you suddenly get smitten by this disease called wanting to reform the world, make it possible for you to find a half dozen people who could put in that $5,000, $10,000, $15,000 at the outset that would enable you, as happened in my specific case, to be able to commission a poll to find out if it makes any sense at all, to pay the full rent in advance for headquarters that puts you up in as an active candidate, to get a mother bill to give you the phone bank. Everything had to be paid up in advance. And I know that I could not have gotten into that race and succeeded under the present rules, because I relied on a half dozen people to provide $65,000 of seed money to get me started. Once I got started, once I achieved that breakthrough into credibility, I was able to go into mass mailings, and I had more individual contributors than the other two candidates combined. But I couldn't have gotten there under the present rules.
You mentioned about the Supreme Court decision in this case being mixed, saying some things were okay, others were not. Looking back on it over the years, would it have been better, would things be better now if the Supreme Court had decided all one way or all the other? What did that mixing of the opinions, what impact did that have?
Well, there's so many bad aspects to this legislation that I would say this: it would be better if they'd gone all one way in terms of no restrictions on individual contributions, or restrictions on everybody, including yourself, which would have clearly and the most absolutely inexcusable under the Constitution. But there are other aspects of that bill that had to be done away with, such as limitations on what could be spent in an individual campaign. Because if you had parity, it'd be impossible for a challenger to ever unseat a member of Congress. Their advantages are too deep-seated, too hard to overcome.
How have your thoughts about campaign financing and finance reform changed, if at all, over these years?
They haven't changed really at all. To me, the reform is full disclosure of who is giving what money to whoever. Then the public can make its own mind as to whether there's anything sinister about the contributions. Now, one of the things that was revealed in the record developed in this case was that most people give to candidates whom they believe in. They are not giving money in order to change their votes. They say, here's somebody I think has the right point of view of what the government of the United States ought to be all about, what foreign policy is about, economic policy and the rest of it. Therefore, I'm going to back him. And in my own case, I had several very significant contributors who never knocked on my door. I take it back. One of them asked if his wife could go to the Senate dining room, and that's it. But there are other things that happen as a result of this limitation that I don't think is being discussed today and ought to be debated, and that is it has created the PACs. Once upon a time, the PACs were there, but they were inconsequential because if I had $10,000 to give to a candidate, I'd want to give it directly and not through a special action group. Well, suddenly, PACs have become very significant actors in the political equation and have become to dominate. Furthermore, whereas I don't think that private contributions are corruptive in 99% of the case, there is an element of corruption about the PAC, because they will say, you must commit yourself in advance that you will vote for this legislation or that legislation or you don't get a nickel. And that can cause people to put their money to commit in advance, and that's wrong. Another aspect of this legislation that people don't quite recognize is that it has entrenched the power of the established forces in American politics. Number one, the two major parties. Number two, the media. Less competition from individuals who happen to have a gripe or objectives. It has discouraged grassroots activity in elections to an astonishing degree. I've seen incidentally these changes because I was a candidate who was defeated, one of those rare incumbents who got defeated in '76, and I ran again in 1980 in Connecticut. So that there has this, the present rules have distorted the whole political process to entrench the power of the powerful and to make it difficult for the outsiders, the reformers, to have a say in the political marketplace.
The Buckley in the case Buckley v. Valeo is Judge James Buckley, Senior Judge of the U.S. Court of Appeals for the District of Columbia Circuit. Thank you very much.
Thank you.
If you've just joined us, we're halfway through a 2-hour special program on the Supreme Court case Buckley versus Valeo, which was argued at the Supreme Court on November 16th, 1975. It's a very significant case, having a lot to say about how members of Congress and people who are running for the presidency are treated. Joining us this evening to take your calls and to offer their comments of their own current perspective and their own experience in the case are Fred Wertheimer. He is now the president and founder of an organization called Democracy 21, but back in 1975 he was at Common Cause when that citizens group was involved in the Buckley v. Valeo case at the Supreme Court. And across the table from him is John Bolton. He's now a senior vice president at the American Enterprise Institute, but then he was an attorney on the Buckley side of the case, and both of them were present at the oral argument from which you are hearing audio excerpts this evening. We're going to continue now with a portion of a recent Buckley v. Valeo mock Supreme Court oral argument that was hosted by New York University's Brennan Center for Justice. The issue in the case, or this mock oral argument, is whether Buckley v. Valeo should be overturned. We recorded this in November of this year in Los Angeles, and it's already appeared on C-SPAN and on our companion network, C-SPAN 2. And for the next 4 minutes, the two attorneys present their opening statements to the mock court. After that, we'll be back to take your calls.
Mr. Chief Justice, and may it please the court. We are here in connection with the review of a decision of the Court of Appeal refusing to apply the case of Buckley versus Valeo to invalidate limitations congressionally imposed upon campaign spending by committee and campaign spending by the individual candidate. In approaching this task, surely a first precept for consideration is that of the necessity of stability in the law of constitutional adjudication. If decisions of this court are to receive the unquestioning obedience that they deserve, they must have staying power and not be subject to the winds of political change. That is particularly true with regard to the Buckley case that we are here considering. That case was not decided by 19th century justices unfamiliar with modern society. It was approximately 21 years old. Nor was it a case that was a 5-4 squeaker. On the points that are here at issue, the case was 7-1 on campaign expenditures and 6-2 on the expenditure of personal wealth. Nor has that decision lain fallow in the intervening years from the date of its decision. Rather, at least 5 cases of this court have applied these precepts that campaign expenditure cannot be legislatively limited, the most recent of which was Colorado Republican, decided just last year.
Mr. Chief Justice, may it please the court. The circuit court below stated that success in elections is linked to spending. The survey, which is in the record before you, shows that 95% of the public believes that money influences congressional elections, and 70% of the people of this country believe that money is the best single barometer to indicate who's going to win an election. Can we live with those facts in a democracy where we must give a share to every equal citizen to participate in the electoral process? We have not accomplished the solutions to those problems, and we need now to find some way to deal with them. The compelling state interests which we must deal with have escalated in the 21 or 22 years, and it's time that they be revisited, as this court has invited, and that we examine again the analysis and the groundwork in Buckley to see if it is sound today. I'm in with my brother Warren's views with regard to res judicata. I've argued it all my life in the courts of this country. But there comes a time when if there was a mistake made, it should be changed, or if it should be modified, it should be modified, and that is the issue that this indeed must face and must make a decision on in light of its own questions.
Taped just this past November is ample evidence of the currency of the issues we're discussing tonight. Our special on the case of Buckley versus Valeo, and we've got Fred Wertheimer and John Bolton here. Gentlemen, we have a from Nancy Martin in Columbia, Missouri, who says, I feel that since the citizens, quote, own the government, unquote, contributions by legal entities such as corporations and labor unions are unconstitutional. She asks, issue discussed during the oral argument. John Bolton?
No, we did not challenge the existing prohibition union contributions. We were after the new provisions that had been enacted, as Judge Buckley said, Watergate. There are serious questions whether those provisions are constitutional, but they were not the subject of the Buckley case.
Fred Wertheimer, this fax for you from George Miller, Somerset, New Jersey. He says, wow, Archibald Cox sounded very weak and unsure. His argument seemed to be that, well, yes, I agree that spending limits may discriminate and so on and so on. I'm editing here. When asked whether the legislators who crafted spending limits had considered such statistics before writing the statute, he essentially said, I don't know. No wonder Valeo lost. Your comment.
No wonder Valeo lost. Archibald Cox was not weak. Archibald Cox has argued more cases before the Supreme Court than people who ever appeared there. The fact of the matter is, if you look at the results of Buckley v. Valeo, the contribution limits were upheld, public financing was upheld, the disclosure requirements were upheld, the spending limits were knocked out, the Federal Elections Commission was knocked out on its appointment power and reconstituted. I don't think it was a loss, and I don't think Archibald Cox was weak at all.
It's important that in the part of the argument after lunch, Ralph Winter was able to get back up and show, in response to the Archie Cox was not able to answer, that Congress had consistently reduced the expenditure limits. That is to say, making them more and more beneficial to incumbents as time went on. I think that was one of the nails in the coffin of expenditure.
I should point out, of the 4+ hours of the oral argument, we have at most a fraction of that, and that we can't, as we like to do in our format, show you the entirety of everything. We just can't do it tonight, so that might lead to impressions that are being formed in these segments that we have.
I think John and I would agree on one point. There's a very difficult problem when you have people drawing rules, namely incumbent members of Congress, for themselves and their challengers. That's a very worrisome problem. Where you come out on this.
It's called Savannah, Georgia. Go ahead, please.
Hi, I just had a statement and wanted to hear your response. I support unlimited spending for whether it be hard money or soft money by candidates, but if you're going to impose limits, you're going to need to impose limits on television. National news media is very biased, and they only report one side of the issue, and that is the side of the candidates that they support, and the same thing with newspapers as well. And so at this type of spending, you're going to have to limit the freedom of the press, whether it be newspaper, television, or radio.
Okay, sir, thank you. John Bolton, was that on the table in these oral arguments?
That was in fact, and that was, you heard just in the last clip, asking about a hypothetical where a candidate ran in a district where the media was against him. Lots of people in this country issues on the media itself in Hollywood. One of the real impossibilities of regulation in this area is deciding how much speech is enough. Those who favor campaign or even campaign contributions, certainly public financing, think they know what the right amount of political speech is. I just think that's fundamentally wrong. There is no right amount, and those who try and create the limits unbalancing the system in somebody's favor or another.
Well, maybe unbalancing it in terms of the and most powerful people in America versus most citizens. Buckley was talking about how what would be wrong with if we could. He started out by talking about 50,000 contributions and then backed off and said 5,000 or 10,000 or 15,000. I wonder how many people listening to the show right now are in a position to give 5 or 10 or 15,000. I would get very, very few. So what? Can I finish? Sure. What you do when you have a system that puts all of its on money is give to relatively few voices extraordinary power in the government process, so that while every voter gets one vote at election time, when you go into the rest of the governing process, the next 2 or 4 years, those few people wind up with extraordinary power at the expense of the rest of us.
John Bolton?
I just answered that quickly. I don't think there's any demonstration that the rich tend in one direction or another. It's really sort of amazing to me how many liberals there are. But even if you could show bias in one direction or another, the answer is full disclosure of these contributions in an unlimited amount. And if the voters are disturbed by them or they're concerned the way the wealth is flowing, they can express their displeasure at the polls.
We want to go back to the oral arguments from that day 22 years ago, but the last caller prompts or the fax prompts a question. Try to keep it the point, because this is an opinion that did come down at 294 pages. John Bolton, what was this case?
The court found some aspects constitutional and some aspects unconstitutional. The easiest way to decide whether they considered it a win for Buckley or a loss for Buckley was they had to allocate the cost of the appendix to the case, the record below. They split it 50-50 between the parties.
Is that your Wertheimer?
It's not my judgment, but it's not worth fighting over. They won some issues that were very important in this case, and we won some issues from our standpoint. From my standpoint today, the biggest, most important issue in terms of putting some in the financing of elections is the ability to provide, in one form or another, public resources into the mix. And that
right.
We did win.
Let's go back to that day in November 10th, 1975, of Buckley versus Valeo, where Attorney Joel Gora and Deputy Solicitor General Daniel Friedman discussed the disclosure provisions for campaign contributions. It's about 14. And John Bolton to take your calls.
This statute, political committees must keep a detailed and exact account of the identification. That's a statutory term. It means name and resident address. The identification of each person who contributes in excess of a year. That's a virtual monitoring of everyone who makes a political contribution in the states. Similarly, all candidates and political committees, whether they be the committee to re-elect the president or a local minority party in California, all political committees for all offices have to file reports disclosing their contributors in excess of $100 a year. And finally, any citizen who on his own spends more than $100 a year on federal politics, independent of any candidate, just goes out and prints up some leaflets backing his local member of Congress, must register and file reports with this commission in the course and nature of his expenditures.
What is the penalty for failure to comply?
The penalty for non-compliance with the disclosure and reporting requirements is, I believe, 1 year in jail. I believe it's a $1,000 fine.
For a citizen who fails to report a $100 contribution?
$100 independent expenditure or contribution. If I, for example, run an ad in the Village Voice in New York or paper, spend $125 on it saying, defeat, vote for so-and-so, I have to file a detailed report with the commission giving the source of my money, how it was spent, and so forth.
Well, we would agree with you that to that extent, the disclosure provisions go too far.
Right.
And
and strike them to that extent, would you then be satisfied with what's left?
Well, striking the disclosure requirement speech, certainly.
Those aspects of it.
Yes, I think we would, Your Honor. I think if this court were to indicate that it reached too deeply in terms of the threshold and swept too widely in terms of the reach, yes, we would be in a position that it's focused to those interests that the government can properly require disclosure for. The problem is that the government interest and associational privacy are run up against each other in this area. Depending on where the line will determine, for example, for a small or unpopular party, whether they and their adherents are going to be free from government harassment or have to expose their contributors. But even the contributor to a major, the Democrats or the Republicans, the $125 contributor, where the threshold is drawn is going to might go on an enemies list or not. And we suggest that
Well, except for its being very awkward and unwieldy, impractical to sweep so broadly, how constitutionally does it differ? How constitutionally is a greater violation of John Jones's rights to private associational confidentiality if his $125 expenditure is recorded? How is that a greater violation than it is of Mr. Mott's or Mr. Stone's rights if Congress could enact a statutory provision requiring that he make a disclosure of his million?
I think in principle...
What's the difference?
There's no difference. Okay. However, I think that disclosure of one's political at whatever volume is presumptively invalid. But at the volume of the large contribution, countervailing government interest in informing the electorate of those individuals who make large contributions in preventing corruption, those countervailing interests come into play. So that's how I would make the distinction between the interest in knowing in the privacy of the $125 contributor and the interest in breaching the political privacy of the $125 contributor. That's how I would draw the line, Mr. Justice.
And one other question now that I've interrupted you. You said you'd be quite satisfied with what would be left after the court accepted your position and struck down these provisions. What would be left vis-a-vis disclosure? Nothing, would it?
Well, it would depend on how the court chose to approach. There is a severability section in the disclosure provision.
No, but you say if you'd be quite satisfied with what would be left with respect to disclosure requirements after we struck down what you tell us after we had held that the Constitution makes it impermissible. There would be nothing left with respect to any disclosure requirements.
In terms of this present statute?
Exactly.
Well, that would depend, Justice Stewart, on the remedy that this court employed. Now, in terms of dealing with sweeping and overbroad statutes, one remedy, the potent medicine, is to invalidate it on its face. I'm not sure that's necessary here. Section 4 of the Act has a effective severability section, which reads, if any provision of this title or the application thereof to any person or circumstance is held invalid, the rest of the Act stands. If this court were to determine, for example, that the failure to make distinctions between the two major parties and all the other small minor parties in terms of disclosure warranted invalidating, I assume a ruling of that kind would leave the regular disclosure provisions in effect. It might be more difficult for the court to make a separation out in terms of the thresholds. I would grant that. But I think that the statute obviously contains lines for separating out major and minor parties.
Mr. Gore, how have we had disclosure and political contributions in this country?
Technically, Justice Marshall, since 1910. Practically since 1972.
Well, you say it's bad? It's been bad all that time?
Pardon me?
It's been bad all that time?
Just hasn't been challenged that we're aware of in terms of the kinds of First Amendment association and political privacy arguments that we're making here.
Since early in this century, there has been, in the language of this court in the auto workers case, a long series of congressional efforts calculated to avoid the deleterious influences on federal elections resulting from the use of money by those who exercise control over large amounts of capital. Congress first faced this problem back in 1907 by enacting a statute prohibiting certain contributions by corporations in connection with elections. In the auto workers case, this court traced at some length the history of the congressional regulation of this problem. What it described as a series of acts to protect the political process from what Congress deemed to be the corroding effect of money employed in elections by aggregated power. Unfortunately, however, as these statutes were enacted, they proved to have so many loopholes that they were virtually ineffective in doing anything about the problem. And beginning in the 1960s, in the late 1960s, Congress held a series of detailed hearings exploring all aspects of the problem. These culminated in a 1971 act, the initial Federal Election Campaign Act, by the present amendments in 1954. Now, this statute, therefore, is not out of the blue. It represents the result of many, many years of study, 3/4 of a century, by the Congress, the body that is particularly expert in knowing the problems resulting from the use of money, the corrupting effect of money on federal elections, and Congress has studied the problem. When things do not work, changes are necessary, and Congress has been willing to change in this area and to try to devise a scheme that will once and for all, we hope, put an end to this problem. The present statute, of course, is a direct outgrowth of the disclosures of the 1972 campaign. There's no need to go into any detail with that sorry and sordid story. It's set out in the record. It's a matter of public knowledge. The huge campaign contributions, the gifts for people who wanted to be ambassadors, the campaign-specific large contributions in connection with anticipated favorable government action, such as the milk producers, the large number of corporate officials who were, many of whom pleaded guilty to illegal campaign contributions, and the evidence that developed of the vast increase in the cost of campaigns in this country.
3/4 of a century of study of this problem by the Congress. That was sustained study or sporadic study?
I would say, Mr. Chief Justice, it was sporadic in the sense that Congress was not constantly looking at the problem, but over times, there are a large number of statutes over the years, in 1900, and starting in 1907 and 1910, in the middle of the second decade, the Corrupt Practices Act of 1925. Gradually over the years, Congress realized that what it had done up to then was not enough to solve the problem, and it looked at the situation and devised what appeared to be more expensive regulatory things. It expanded the type of controls. It extended during the war the prohibition on gifts from corporations to unions. As problems developed, Congress studied them. But my point is that over a long period of time, Congress has considered these problems, studied them, and devised schemes to deal with what it perceived to be an increasingly serious evil in the body politic, the corruption of federal elections by the use of money. And the cost of these campaigns has risen at a staggering rate. It's really a staggering rate. And page 35 of Mr. Cox's brief, there's a chart which shows the increase in campaign costs reflected show increases in the consumer price index. And what it shows is over a 20-year period from 1952 to 1972, after adjustments to reflect the cost of living, the cost of congressional races increased more than 300%. And the 10-year period, 1962 to 1972, the cost of presidential races with the increased more than 450%. And by 1972, it was estimated that the total cost of elections in this country exceeded approximately $400 million. Now, what is the consequence of this escalating cost? It's a vicious circle, because when one candidate sees another candidate spending more and more, he's compelled to spend more and more. The cost of these campaigns increase, the candidates naturally turn to where the money is. The easiest source of money, those are the wealthy interests. once a wealthy interest gives a campaign contribution, his competitors, other businessmen, also feel obliged to give because they're concerned that if they either they will be discriminated against by government officials or their competitors will gain an advantage as a result of these contributions. And thus the candidates, as a result of this thing, feel more and more to the sources, the large sources of campaign contributions. And it's not surprising with this history that by the early 1970s, there was a tremendous feeling in this country that you couldn't trust the government, a lack of electorate confidence in officials, the notion that somehow people could be bought. If you gave enough money, if you gave enough, could be bought. And conversely, correspondingly really, the average man who was not very affluent, who didn't have access to all these sources, he believed that it was rather futile for him to try to play an active role in the campaign. For one thing, if he wanted to run for office, he knew he couldn't raise these sources of money. And secondly, if he wanted...
Why couldn't he?
Well, just...
It isn't. You've painted with a very simple brush. It's considerably more subtle than the way you've described it to us, isn't it?
Well, I think...
People often make contributions to a candidate who expresses the donor's views. They don't go out and buy them, do they?
Well...
It's not as simple, at least. It's a little more subtle than you've described.
It may not be...
You would concede that, wouldn't you?
It may not be quite as simple, Mr. Justice, but I do think it's a very serious problem. As a good example, I think, of this is evidence in the record that in many campaigns in recent years, the same interests have contributed to two candidates who are running against each other.
Yes.
And that hardly suggests that they have a strong commitment to one candidate. Those people are obviously hopeful.
But if it's the same amount of money, it's the same as though that donor had made no contribution at all, isn't it?
Perhaps or perhaps not, but with this exception, Mr. Justice, that both of these people, whoever is the victor, is likely to feel a sense of obligation to the person who gave him this contribution.
Wertheimer, I want you to explain what was going on in that exchange, but before you do that, this is 22 years ago. What memories does hearing these voices again after 22 years bring up? Do you have a clear recollection of that day now?
No, I don't have a clear recollection of that day, but in terms of these specific arguments, but I have a clear recollection of the momentous nature of that day. I guess I probably didn't fully understand the breadth that we were dealing with, even though I saw it before me, because you really are dealing with a wide range of very fundamental questions that go to the heart of the way the political system is going to function, not just during the campaign process, but during the governing process.
So, this exchange we just heard, what was happening there?
Well, the second part of the exchange was kind of a broad presentation. The first part of the exchange, argument over the challenge to the disclosure provisions in the Act as being too low for candidate contributions and expenditures, and they were challenged in terms of their application to minor parties and independent candidates. And they were challenged with respect to the independent expenditures that were made independently from campaigns, from candidate campaigns. And by and large, the disclosure provisions were upheld as enacted. There was language in the opinion that said that you had to be sure to give a reasonable opportunity for minor parties in the future to disclose their contributions. They would be harassed. But the disclosure provisions of this act were on the whole, upheld by the court.
John Bolton, your take?
Well, Joel Gora, who argued first in that clip, really had the most difficult argument to make on behalf of the plaintiffs that day, because his argument was different than our attack on all the other sections of the statute. We could have lived with most of the disclosure provisions. And large, they were positive, but we were concerned with their applicability to small and unpopular political causes. So Joel was trying to make that point to the court. As Fred said, I think the court has it, although it didn't strike the disclosure provisions down, it did make it clear they had heard his argument, and there have been cases where parties have been able to avoid disclosure under the campaign finance law.
You too. Does listening to these conjure up thoughts, memories that you hadn't had before?
Well, the thought that conjures up for me is how much better we were doing in the court than we had done in the court below, the D.C. Circuit, where only one minor provision actually applicable to common cause was declared unconstitutional. The D.C. Circuit at that point, with a few notable exceptions, was really a bunch of altar boys for the regulatory state. When we got to the Supreme Court, I thought we got a much better hearing.
Fort Smith, Arkansas, you're on the air. Go ahead, please.
Yes, sir. Thank you. I don't really where to start. Tell you the truth, average American, and like one gentleman there pointed out, I cannot afford $5,000, $100. I mean, especially here at Christmas. I could. I would like to contribute to candidates. I see so much across the system, and people are afraid, and they are aware. Today I watched C-SPAN, and it was the talk show radio people were bragging that they put into conservatives. And another thing that scares me, you talk about money, is you've got 5 major corporations that own all the newspapers in the United States. 3 different people. I forgot NBC and so on and so forth. But the Supreme Court in 1975, you know, that is almost the last vestige for a common man, you know, to go and get justice.
All right, sir, thank you. Did the media issue ever come up in the way that this caller is suggesting it should come up today?
Not in that way, but we did talk about the impact of the media on a race where an unknown challenger opposing a very popular incumbent with the media team needed to spend large amounts of money to make his cause known.
One of the interesting and complicating aspects of campaign finance laws is that they apply to 2 things at the same time. 2 elections and the running and spending, raising and spending money on elections. But they also apply to the potential impact of politics on government decisions between elections. And so sometimes you have provisions that serve one purpose that people will argue do not necessarily end up in the from an election standpoint, but still are very, very important from the standpoint of protecting the integrity of the political system.
We have this fax from C. Coggin on Buckley, and the question is, how could attorneys and justices assume that freedom of speech is the same as freedom of expression? Speech is a form of expression, but expression may not necessarily involve speech. But the First Amendment addresses only speech, and the definition of speech words articulated by mouth. Is this mere semantics, or does he or she have a point, John Bolton?
No, our basic argument could be summarized very simply. We said money is speech. You can't advertisements. You can't have a hall to give a speech in. You can't get flyers out. You can't communicate today and really throughout history without the expenditure of money. So regulating money and speech was a little bit like saying a newspaper budget can only be so much. That's regulating the newspaper's speech. We said it was regulating political speech.
Well, you noticed you talked about the expenditure side. And the court on the expenditure side did, in effect, equate money with speech in terms of the ability to reach and communicate to people. But it did not do the same thing on the contribution side. There are implications of speech when someone makes a contribution. But the contribution is not speech. It is given to someone for them to be able to speak. It is more indirect, and its effect on speech is overcome by the fact that giving that money to John might well corrupt him and corrupt government decisions, and therefore it can be restricted.
There is one important anomaly in this decision, though, and that is that the statute originally contained a limit on what an individual could spend if he himself were a candidate. The court struck that down as a constitutional expenditure limit, but the result left is that wealthy individuals can spend money on behalf of their own candidacies, but I, as a not-so-wealthy individual, can't contribute to another non-wealthy individual to give that person a more competitive chance in a race. So the result of the constitutional analysis, because it tried to distinguish between contributions and expenditures, I think incorrectly, was to give the rich candidate an advantage.
So you would support that limit on the wealthy?
No, I'd like the contribution limit.
What was that dollar limit on the individual's right to spend?
$25,000 per.
Okay. $25,000 for a House race, $35,000 for a Senate,
right.
$50,000 for
procedural matter, and that is that we have been illustrating these oral, after all this is television, with some pictures. They are drawings done by Supreme Court artist Betty, formerly of NBC News, and in one of the drawings that we show in the television audience, there's an empty seat. Why is there an empty seat during that oral argument?
Well, Justice Stevens recused himself. I think it was
Douglas, I think, who was ill.
And that would explain the absence.
Yeah.
Did it have any significant outcome or impact on the outcome of the case?
Not on the ultimate impact, but about this time in 1975, as the money was about to become available in the presidential election, we moved to prevent that from happening. The court hadn't rendered its decision. And I think the entire Washington community was stunned at the result, because although our motion was denied by an equally divided court, 4-4, which foretold that some part of the statute was going to be declared unconstitutional.
All right, next call is Tonopah, Nevada. Go ahead, please.
Good evening. First, I'd like to thank C-SPAN for bringing a really important issue before the public. I have a question concerning Buckley versus Valeo and a comment. Question to both of your guests. The First Amendment says Congress shall make no laws abridging freedom of speech or freedom of the press. How did 7 Supreme Court justices decide that Congress shall make some laws? I really don't see how Congress has any power to make any laws whatsoever concerning freedom of speech or freedom of the press. The second issue is the federal government is spending $1.5 trillion a year, has millions of laws, rules, and regulations. So long as Congress believes it has were never granted to it under the Constitution, it is to be expected people will spend billions of dollars a year trying to protect themselves from Congress or trying to get a check from Congress. I'd appreciate it if you...
Fred Wertheimer.
Well, government is large, the stakes are large, therefore people, if they're given the opportunity, will be prepared to invest very large sums of money in order to influence government. That's basic reason why contribution limits were passed, why corporations and labor unions have been banned, corporations since 1907, from making direct contributions in campaigns. On the question of restricting freedom of speech, at least in terms of the Supreme Court in Buckley v. Valeo, they came to the conclusion that there was a compelling state interest in limiting contributions, and they did not equate campaign contributions with speech in the way they did with expenditures in campaigns.
John Bolton, did the statute, or is any statute like this with dollar limits linked to some inflation index?
This statute, there's some state statutes that are, but I think one of the go back to that caller's question for a second. And one of the important things to understand is that the court's First Amendment analysis that led to its decision that limits were unconstitutional, I think was not really carried through in its analysis. Bear in mind, our challenge was a facial challenge. It was just read the statute and hold it against the First Amendment, we argued, and you can say it's unconstitutional. It is yet to play out in many cases as the statute has been applied the last 20-plus years, what its effect has been. I think there's a chance in subsequent decisions additional parts are going to be struck down.
Glenside, Pennsylvania, you're on the air.
Good evening.
Good evening.
I had a question for Mr. Bolton, as he represents the folks who think there should be no limits on contributions. As far as the intellectual underpinnings, I would ask him whether he agrees that there should be a limit on foreign contributions, and if he does think on those, is that because those people can't vote? I know that there are people who come here legally, have freedom of speech. They do not lose their freedom of speech rights as long as they're here legally, and foreign American subsidiaries of foreign corporations are allowed to contribute, and they are folks who cannot vote. and people are not necessarily have to register to vote contributions. So that's my basic question.
All right, sir, thank you very much. How about you, John Bolton?
Well, there are a lot of aspects to that. Let me try and simplify and say, I think as a general proposition, foreign contributions are prohibited, and I think the intellectual justification for that is we have a political system here to elect the governing structures of the United States, and I think those who participate can both reasonably and of necessity should be limited to Americans.
Carmel, California, go ahead.
Hi. First of all, I got to thank you for putting this on. This is a very important debate that America should be discussing, and my hat's off to C-SPAN. I generally agree with the Buckley Valeo vision, with the exception of the money equals speech. When it comes to that point, someone with $10 million obviously has a whole lot more speech than I do. So I don't think that was the appropriate basis or assumption that we should have started out with. A woman named Nancy earlier brought up the thing about PACs and how they're bad, and I think one of the gentlemen here did also. San Diego, some 20 years ago, passed a law which I think we should be looking at, which said no non-individuals can make contributions. That means no businesses, no corporations, no PACs, no labor unions, only people. I'd like to hear you discuss that, please.
Let's hear from Fred Wertheimer.
Well, when the court concluded for purposes of expenditures that money was speech, obviously they made a judgment not separate out money from political expression, and those circumstances, they concluded that it was a violation of the First Amendment. They rejected a series of arguments that were made in this area, which are very important arguments, even if you buy the final decision of the court. They rejected the notion that that those with a lot of money should not be able to drown out the rest of the citizens in the electoral process. Again, we are a process where if you look to the actual decision making, it's one citizen, one vote. But they rejected the idea that those with the greatest resources should not necessarily be able to drown out a larger number, and they rejected it on the basis that the Constitution says that every individual has the rights to express themselves without restriction in the political arena. They also rejected the idea that you could establish any kind of rules for the electoral process. It was conducted, kind of a playing field set of rules. That part of the decision is problematic in the sense of trying to ensure you have an honest and fair electoral process. John points out that he could see parts of the contribution limits falling at some point down the road. There are who are in the business right now of trying to relitigate the expenditure side of this as well. So I don't know that we've seen the end of Buckley v. Valeo on either side of the equation. I probably won't be sitting in the room when it's re-argued, but John, I imagine, is young enough that it'll be there.
Well, we're going to go on to hear more from that oral argument of 22 years ago on campaign funding by the government. But first, this last call in this segment from Libertyville, Illinois, home of Adlai Stevenson. Go ahead, please. You're on the air.
Thank you. I appreciate much the work that you are doing with C-SPAN.
Thank you.
Really fantastic. All the big givers, though, are the ones that own the press and the media. For example, I mean, it ends up that as a voter, I end up really... It's unimportant to me if I should give them $100 or $1,000. I mean, when I'm overcome by some very big givers, when they give to both ends.
Caller, what do you think the solution is? Why don't you offer what you think the solution is, and maybe our guest can respond on whether that would ever see the light of day in the Supreme Court?
Well, I was just trying to ask and find out some enlightenment. For instance, today, there is the case in front of the court about ADM. I mean, it seems obvious that they really violated the the law.
Okay, sir. Thank you. Is there a constitutional, well, I guess it's at the heart of the whole case, and how you would affect the power of news media and other media organizations?
I think that is the central problem the political regulators face, and that is that election campaigns, as important as they are in shaping public opinion, are only a piece of it. And yet that is the one area I think that there's any doubt there's constitutional authority to regulate. Let's say we had a debate over regulating how many editorials the Washington Post could print on any given day. If we tried to pass a statute that limited Washington Post editorials or newspaper editorials generally, be struck down as unconstitutional. Newspapers, magazines, the media have a tremendous impact on public opinion. The problem with these precise regulations of political campaigns is that it distorts the process, it focuses too narrowly, and it leads people into a whole range of other activities in an effort to affect that some people indeed are even now complaining about, leading to calls for more regulation. The answer is to take a bulldozer left of this statute, clear the field, and let the people decide what kind of campaigns they want.
If we're going to get it all in tonight with these segments from the oral argument, we have to continue, and we go on now to this segment from that argument of 1975. Attorney Bryce Claggett and Lloyd Cutler discuss the federal government's involvement in campaign funding. It's about 11 minutes. And we'll be back after that with more of Fred Wertheimer and John Bolton to take your calls.
The subsidy amount that candidates can receive under matching grants is made wholly dependent on the private contributions a candidate has raised. That is, it's a wealth criterion similar to the one you struck down in Bullock versus Carter and Lublin versus Panish. Surely what should matter is the number of contributors to or supporters of a candidate. Instead, a single contributor can command the matching funds checked off by 250 of his fellow citizens on their tax returns. The entire scheme rewards the candidate who gets into the race earliest, who can command the largest number of $250 contributors, and who is supported by special interests which can easily help him meet the 20-state requirement. A candidate who comes in at a later stage, perhaps in response to some new development or some newly perceived political issue, is heavily disadvantaged. The provision is exactly in this way. That is demonstrated by the figures on page 52 of our reply brief, showing what the presidential candidates have raised to date and what they have on hand. It is apparent from those figures that the great bulk of available federal funds is likely to go to only 2 of the 12 present candidates, Governor Wallace and Senator Jackson. Most of the others, even those who have raised substantial private funds, have dissipated almost all of them before the campaign for votes even begins.
What page of your reply brief?
52.
Thank you.
Have dissipated almost all the funds they've raised. You can see that in the right-hand column showing what they have on hand in a desperate attempt to raise more small contributions. Most of these candidates will be so crippled for funds that whatever federal matching grants they receive will not prevent them from being driven out of the race at a very early stage. This legislation has made money more important in campaigning than it was before, not less important as it allegedly was supposed to do. Those problems are compounded by the fact that the mechanism for dispersing the matching grants is so fraught with uncertainty and so dependent on diaphanous prophecies that have to be made long before they can be made, that the may be unfair or random in the extreme. We set out some of these problems at pages 70 through 73 of our reply brief. The day after that brief was filed, the Assistant Secretary of the Treasury, testifying before the Federal Election Commission, confirmed every one of those concerns we'd expressed and added some new ones. We lodged his testimony with the court. It is now clear, after his testimony, that funds may be inadequate to pay all the candidates who qualify, and that what funds are made available will depend on guesses as to what third parties may enter the ultimate general election campaign and what their election day performance might be, this in December or January. And there is a distinct possibility that all the available funds will be exhausted by the first two candidates who qualify, Wallace and Jackson, thus discriminating against those who qualify thereafter. Finally, the difficult decisions that must be made by a partisan political appointee. President Ford, Secretary of the Treasury, is going to decide how much President Ford and Mr. Reagan get for the New Hampshire primary. That's a curious Watergate reform. Now, there are other discriminations that I haven't even been able to touch on, like the exclusion of Appellant McCarthy solely on the ground that he's an independent rather than affiliated with a political party from any subsidies at any stage. That some problems of this nature, whether the same ones or other ones, will be present in any kind of federal subsidy scheme that's formulated. Any such scheme will establish parties by favoring them over others, just as this scheme establishes the two existing major parties. As Mr. Justice Douglas wrote in Abington School District versus Shemp, the most effective way to establish any institution is to finance it. Such political establishments, we think, cannot be squared with freedom of association or with the general welfare, or indeed with the provisions of Articles 1 and 2, which contemplate free elections in this country. Most of these objections wouldn't apply to a genuine check-off scheme, whereby each citizen would designate a party or a candidate to receive be checked off. There's nothing impractical about a scheme like that, as we have shown in our reply brief. If there is any warrant for federal involvement in the campaign funding mechanism at all, method would plainly be a less intrusive means.
Mr. Chief, may it please the court, since Mr. Claggett has not invested much of his oral argument in his arguments as to the power of the federal under the General Welfare Clause to provide for public financing of election campaigns, and since he has not devoted much time to his argument that any such plan violates the Establishment Clause of the First Amendment, which he moves by implication over into the free speech section of the First Amendment, shall concentrate, as he did, on the alleged discriminatory effects of this particular proposed public financing plan against the smaller parties. I'd like to first that the appellants show little proof of injury to them to support their claim that these provisions should be voided before they've had a chance to work in a single election. Of the 12 plaintiffs in this action, only 4 assert any interest in the public financing of presidential campaigns. One is Eugene McCarthy, whose claim is wholly academic as to discrimination because he has testified on deposition in this case that he would not accept public financing even if he was eligible.
Well, does he have no stand reason to complain that somebody else is getting it?
If this were an attack on any public financing, Mr. Justice Rehnquist, yes, but the attack, at least on the discrimination front, is an attack that the public financing provided to the so-called major parties discrimination against him.
And you say he can't attack that because we
say he presents no case to you that he is being discriminated against by reason of the 5% provision or the money before or money after provisions when he said he would not take it anyway if it were offered. The same is his party, his committee for a constitutional presidency, which is a second plaintiff. The same is true of the Libertarian Party, which testified on deposition that it would not accept public financing if offered. And in the case of the fourth plaintiff, the Conservative Party of New York, the Conservative Party of New York has never nominated a presidential candidate who was not also a candidate of a major party and thus entitled to the full allotment. And no other political party or any present aspirant for their 76 nominations is before you in this case, although the Socialist Workers' Party has filed an amicus brief. So most of the fascinating hypotheticals which fill appellants' briefs and our replies, what would have happened in 1856, Mr. Justice Stewart, whether the equal amounts for the first and second parties are unfair as between the two of them, or vis-a-vis a third party, what would have happened to Bull Moose and Eugene Debs, we say are just, at the moment at least, fascinating for the political hot stove league that can justly and should better be left for another day.
Cutler, refresh my recollection, if you can, on the largest percentage of vote that any third party has ever received in our history.
It depends on how you define third party, Mr. Chief Justice. If you define
one after the first two in any particular election.
Well, if you say after the first two in any particular election, and if you ignore some of the very early elections in the 1832 period and thereabouts, I suppose the largest percentage would be the percentage compiled by Bull Moose, by Mr. Roosevelt when he was running in 1912, which I believe is of the order of 29 to 30%. The reason I asked about how you define a third party is there are several other new parties running for the first time in a new election that did much better than that. There are some, I'll find my reference in a moment, such as
nearest to Mr. Theodore Roosevelt's vote, the Senator La Follette back in the 20s?
I haven't. Senator La Follette got about 9%, I believe. All of these figures are, well, I believe they're in the joint appendix at about pages 34 and 35 of Volume 2A. But there are candidates, of course, like Mr. Fremont, the Republican candidate in 1956, who finished as the second candidate in that year. There are candidates like Governor Wallace in 68, who got, I believe, something like 12.5 to 13.5% of the total vote. Indeed, there are in the 36 elections since 1832, defining small parties as parties coming on the scene for the first time, or true small parties, there are 10 examples in that table I referred you to. It's pages 35 and 42 of Volume 2A. 10 examples in 36 elections of candidates who achieved better than 5%. So it's in no sense an impossible dream.
That oral argument in Buckley versus Valeo was 22 years ago. It was 4.5 hours long, and that's the last segment we're going to be able to show you tonight. And obviously, it's only a fraction of that whole day, and our guests were both there. Fred Wertheimer, what about that segment and your take on the issue of public financing?
Well, there were a series of arguments about the public financing provisions that went to the question of the formula for distribution, how the matching funds would be distributed in the primary election. But the bottom line was the entire public financing provisions were upheld. To me, that was the most important piece of the decision, along with the contribution limits. But in the long term, going to the earlier caller, public financing is a part of the solution to this problem. Funds for serious candidates, incumbents, and challengers to communicate to voters. Free or low-cost TV time. One of the ways you deal with this problem is greatly reduce the cost of communicating on the airways belong to the public, in my view. But you won't solve this problem by John's formula, which is just full disclosure. Because if I could just comment on it for a second. Full disclosure tells you how bad the problem is. It doesn't solve the problem. We now know what happened in 1996. It doesn't solve the story it tells. You need other remedies in order to deal with the dangers here. And you know, full disclosure is a fallacious concept. The information reached the voters. It's filed at the Federal Elections Commission. It's published a little bit. There's no formula for getting it to all the voters in this country.
As we run out of time, we are going to give John Bolton a chance to... But first, this call from Olympia, Washington. Go ahead, please. Olympia, Washington. Olympia, Washington, go ahead, please.
Yes.
Go right ahead.
You want to hear from the public, yes?
Yes, we do. Please, do you have a comment for our guests?
Well, most of them seem to me to be irrelevant. I think the bottom line is that public financing is the only way to go. The idea that money equates free speech is ridiculous because the lobbyists have plenty of time to express themselves, that is, to the congressman, just as we do.
All right, ma'am, thank you very much. That seems to segue well into the opportunity we're going to give you, John Bolton. What do you say to that caller?
Well, as populism retreats around the world, only in the public financing of American elections do we still see advocates. Public financing has this basic dilemma. Either you fund all candidates, in which case you're covering every lunatic fringe element that gets out there, or you restrict it, as the does pretty much to the two major parties. And our argument, again, a facial challenge in Buckley, was that these various mechanisms that were set up were discriminatory. What's important today, though, is that the court, in a part of its decision that was very explained and not argued really in the case, not only upheld public financing, but upheld limits in connection with those candidates that take public financing. And I think that's the real problem that we face today, and one of the reasons why we've encountered these some of these difficulties that you've all been reading about in the newspaper.
In the closing minutes, we're going to try to do a lot of things in a little bit of time, so I'm going to read this fax and get your reaction to it, and it's aimed at you, I think, Fred Wertheimer, and that is the Valeo argument seems to be based on two assumptions that I find hard to accept. A, money and those who have it are evil. B, we live in a democracy.
No, it's not based on the notion that people are evil. It's based on the notion that very large sums of money have the ability to corrupt public officials. Not a new argument, not new to this country. I don't know where socialism came into this argument, but most Western democracies have public financing of elections. This is not a concept that's solely limited to the United States of America. There is a danger with huge sums of money in influencing public officials. It's been going on for centuries.
San Antonio, Texas. Go ahead, please.
Hi. Instead of trying to constrain people's voluntary actions by telling them they can't contribute money, we could charge money to use the electromagnetic spectrum for broadcasting, and the money could be spread to all the people of the country. And those who want to put some of that money toward forums that would invite candidates for discussions on radio and television, etc., or just a town hall, come in person. If you want to put your money that's your share of the electromagnetic spectrum, you can do that. And then
All right, sir, I think we've got the point. John Bolton?
Well, that may be a little bit above my technological capacity to understand, but I do think the concept of voluntary and associational political activity is at the core not only of the First Amendment, but the way we consider society. And I still haven't heard, 22 years after Buckley, convince me that some people know what the right amount of political speech is and should be allowed to impose on others.
I think we've got time for one last call. This from San Jose. Go ahead, please.
Yes, I had a question. What about the possibility of making use of ballots for the candidates to, okay, if somebody's running for political office, if you have ballot statements that are already distributed by the state...
What do you mean ballot statement?
Okay.
Caller, please be brief. We're running out of time.
Okay, in California, there are ballot pamphlets that are sent out to the individual voters.
And everybody...
everybody...
And it includes the statement of each candidate's views?
No, it doesn't. Running for a nonpartisan office, but not for partisan.
All right. Are you familiar with ballot statements, and does it apply to this issue?
It didn't apply in this case.
Well, but it's only a small part of communicating with a constituency.
Well, let's go back to the last 2 hours we've spent, and we're less than half the time that was spent on this issue 4.5 years ago. What is significant that you out tonight?
Well, we didn't discuss the Federal Election Commission, which the court declared unconstitutional in its appointment power, but which was then reconstituted. John may want to about this. This was one of their challenges. Ironically, it was declared unconstitutional because it gave members of Congress the power to make direct appointments to an executive agency. And unfortunately, in my view, when Congress reenacted it and gave the power to the president, they did a de facto carrying forward of the same position. And Congress actually, for all practical purposes, has named a number of those commissioners since it was created.
John Bolton, is there something in this case that was so significant that you think we should have gotten to tonight?
Well, I think that the separation of powers questions that Fred has just raised in our challenge to the Federal Election Commission really are important. When the court struck down the Federal Election Commission, it was the first federal agency declared unconstitutional since the deal. And there were other things that flowed from it later, the subsequent declaration that the veto was unconstitutional, really had I think an impact that we're still seeing today, even in debates over things like the independent counsel investigating executive branch authority.
Fred Wertheimer, if today's court were to have heard that argument and voted on this case, any ideas what would happen?
We're going to find out. Issues will be back before this court. I don't know. I think this court is a split court. There are clearly a couple of votes on this court for limiting contributions and expenditures. There are maybe 3 votes for knocking out contribution limits and expenditures, and then there's kind of a body in the middle. I think it's an open question right now.
I think it's very hard to tell. I agree with Fred on that. I'd like the chance to get back in the field on it.
Well, we're about. I'd like to thank former NBC Supreme Court sketch artist Betty Wells, whose sketches we've used during this program to help illustrate the courtroom on our television coverage.